Greetings and welcome to the Law of Evidence, Transportation from American Jurisprudence. So we left off last time. We were going over different forms of judicial notice, and transportation is the next topic. If anyone here has just arrived, please hit the like, because it seems like this one's really not getting the notification out. But it's a very important topic when it comes to judicial notice, so let's get right down to it. So we're going to be reading from American Jurisprudence, second edition, 1998, evidence. So this is a 1998 supplement. It's not the most current, however, considering this topic, it is foundational when it comes to evidence. So almost everything here still applies. The only thing is there would be newer cases that would only make things a little bit more complicated. So let's get with it here. We're on to Chapter 6, Transportation. Starting on Section 83, Motor Vehicles and their operation. Before we get started, just to remind everyone that this is strictly to be used only for the entertainment, educational purposes of this YouTube broadcast, not to be used, misconstrued, or mispurposed for anything other than that, including anything professional, personal, business, legal, lawful, tax-wise, or financial. So please don't do this at home. All right, let's get started. Courts have judicially noticed matters as basic as the definition of an automobile. We're just talking about motor vehicles, but courts have judicially noticed matters as basic as the definition of an automobile and as specific as the effect of a stone thrown at a passing car. Already we've heard motor vehicles, automobiles, cars. Numerous decisions have judicially noticed the function of car parts, including signal devices, headlights, and tires. Courts have judicially noticed the effect intoxication has on the driver, the annual number of alcohol-related traffic accidents, and the carnage caused by such accidents, as well as highway fatality statistics generally. Courts may take judicial notice include the normal purposes for which a vehicle is used, although a court cannot take judicial notice of the characteristics of either a trail bike or a particular brand of motorcycle. I've seen this before too. In resolving whether a trail bike is either an automobile or a midget automobile within insurance policy's exclusive clause. In addition, courts may take judicial notice of the proper positioning of a towed vehicle. The fact that motorcycles generally emit considerable noise through their exhaust systems. Courts may also judicially notice types of driver conduct, which are usually indicative of negligence, of the inherent dangers of certain types of driving maneuvers, such as making a left turn. Is that really that inherently dangerous? Types of driver conduct which are usually indicative of negligence. Could that be, this is 1998, so cell phones weren't prevalent at the time like they are now. The inherent dangers of certain types of driving maneuvers, such as making a left turn, and of the fact that passengers rely on the driver for control and management of the car and to exercise the required degree of care. Furthermore, it is generally agreed that the reliability of radar to measure the speed of motor vehicles is a proper subject for judicial notice. Interesting there. 90, footnote 90, let's see what that one was. Idaho. So as you see here, the insurance companies are usually the most concerned with these definitions. Regarding the judicial notice of the nature an intoxicating quality of alcoholic beverages, generally C. Okay, we could get that later, but in the meantime, let's see Section 84. Driver reaction times. It is not possible to act instantaneously upon perceiving danger. Some time elapses between the perception of danger and the physical reaction to it. In litigation arising from traffic collisions, courts readily acknowledge and accept this fact. So some time elapses between perception of danger and a physical reaction to it. So courts readily acknowledge and accept that fact. Courts are divided, however, as to the propriety of taking judicial notice of the length of time it takes the average driver to react, of course, because they're litigating a particular instance. Several courts have taken judicial notice, usually based on state publications of various sorts, that the average driver reaction time is anywhere from half a second to a full second. Other courts have refused to take judicial notice of an average reaction time. Even where courts will take judicial notice of driver reaction times, a court may require that the driver be verified. That the information be verified. How do you verify the reaction time of the driver? Well, here we go. For example, a trial court does not abuse its discretion in refusing to take judicial notice of reaction times, braking distances, and stopping distances when a party's exhibits do not identify their sources, and therefore the information they cannot contain cannot be verified. Remember, that's one important part about information like this. It has to be readily verifiable by an unquestionably authoritative source. No reasonable person would. All right, here we go. Rid of error. At least 1/2 of a second is required after danger appears for the average motorist to transfer his foot from accelerator throttle to brake. Here's an annotation: judicial notice of driver's reaction time and of stopping distance of motor vehicles traveling at various speeds. Right, we're on to section 85. You can see we got a really thick chat tonight, so I won't be answering any questions on this section here. We'll have to wait till the next section. Section 85, boats, ships, and shipping. Courts have taken judicial notice of matters relating to travel by boat, air, and rail. For example, courts have judicially noticed the nature of a boat's speed in knots, the function and effectiveness of boats' radars, and the consequence of a boat's severance from its berth. Consequence, wow. So that's footnote 98 versus Caribbean SS Company. Texas. The courts will take judicial notice of matters of common knowledge relative to ships and shipping. It is common knowledge that a ship is a wanderer to many ports of call, and thus, more often than not, is far from the direct control and supervision of its owner. Wow, a ship is a wanderer to many ports of call. It is far from the direct control and supervision of its owner. It is also common knowledge that the master of a ship is charged with full enforcement of discipline of members of the crew. That's common knowledge to the brig. Right, we're on to airlines and airports. Section 86. Judicial notice has been given to information relating to the types of airlines that service particular airports. The impact of an airport upon surrounding communities, and the psychological and emotional effect that an airplane crash has on the nearby population. Wow. that can be judicially noticed. But in the absence of qualifying evidence, a court should not take judicial notice of information concerning events revolving around an airport in another state. Wow. This is the air crash disaster near Chicago. Footnote 4. The emotional effect the airplane crash had on a nearby population. So it has been judicially noticed. Interesting. All right, we're on to section 87, railroads. All right. Courts have repeatedly affirmed the fact that the railroad industry is a business which is constantly open to public observation. The manner in which railroad companies conduct their business has been followed for so long a period with such uniformity that the court is bound to take judicial notice of its general features, like time zones, right? It is also a matter of judicial knowledge that the demands of commerce require in the transportation of freight that cars of one company be hauled over the road of another. Demands of commerce require. The courts will also take judicial notice that a particular railroad company is a common carrier engaged in the transportation of persons and in interstate commerce. Since judicial notice is taken of the location of the principal cities of the United States and their distance apart, a simple computation will ordinarily demonstrate with approximate certainty the time of travel between such cities, and the courts will take judicial notice of the result of this computation. It is clear, however, that judicial notice cannot be taken of the usual time of the arrival and departure of trains at a particular place. So it's whatever is been tabulated here. And do the computation. That's something that could be readily verified by the judge, even. Courts have judicially noticed that railroad grade crossings are places of danger. And that notwithstanding precautions taken by railroads to prevent grade crossing accidents, a substantial number of motorists are negligent in approaching them. It has also been judicially noticed that it is dangerous to stand close to a moving train, both because of overhang and suction. I guess you have to put that on notice, huh? Well, yeah, these railroad companies, the old term getting railroaded. All right, well, that takes us to the end of this section. Our next section will be section 7, language and communications. So this one will be an interesting topic as well, and this will be the feature of our next live stream. So let's jump over here to the chat and see if we have anything else. Please make sure you hit the like on your way out to make sure people know that there's good information to be had right here on this channel. And please like and subscribe and hit that bell notification so you can get notified of the upcoming streams. And until then, I hope to see you all on the next one. Peace out.